Well, good evening. It is evening, and welcome to a special presentation, a special discussion that we're having together. Myself, Michael Swain, 4SA, our wonderful legal assistant and advisor and lawyer, Nobukosi Zulu, joining us, in fact, from the US of A. And of course, our head of legal, Liesl Pretorius. Great to have everybody here tonight. And obviously, what we're going to be discussing is probably one of the most concerning developments legally that we've had, certainly that I could think of, which is the signing into law of the Prevention and Combating of Hate Crimes and Hate Speech, which is now an act. The President, Mr. Ramaphosa, signed this on the 9th of May, at which point this law is in force and enforceable. And we have obviously been very concerned about this. We've been fighting this. We've been lobbying for all the different protections that we need for the definitions to be strengthened for the last 5 years. But Liesl, perhaps we can just start off by asking you, tell us, what actually is this law now about? What does it say? What does it do? And what are the main concerns that we are having?
Yes, Michael. So this new law criminalizes hate crimes and hate speech. We've never really had an issue with the hate crimes component, but we have serious concerns about the hate speech component. So what is this new crime of hate speech? Well, without going into too much legal technical detail, in a nutshell, hate speech is defined as any expression that consists of the following elements. One, it is harmful or it incites harm, and it promotes or propagates hatred. And thirdly, against a group of people specifically listed in the bill. So that is the short answer of what hate speech is in terms of this new Hate Speech Act.
So I think let's just drill down a little bit more, because obviously, as we've often said, the devil is in the definitions. And one of the main concerns that we've had about this particular law has been the fact that it is widely defining hate speech. And maybe, Nobu, you could maybe pick this one up. The Constitution obviously protects all speech except for hate speech, and hate speech is defined in the Constitution. And maybe you could just help us with, how the Constitution defines hate speech, and therefore why or how this law goes beyond the constitutional definitions, which is obviously the basis for why we, and I think many others, believe that it is in fact unconstitutional in its current form.
Yes, thank you. So our Constitution is very specific about what is hate speech. And Section 16 is very clear. It's a type of speech that propagates war, that incites imminent violence, and it's a type of speech that advocates for hatred based on some of our protected grounds in the Constitution. And these are the grounds that are listed in the Constitution that one should not discriminate against. And this type of speech has to rise. There's a threshold of a level that it has to rise to. It has to be speech that propagates hate, not speech that I hate. It shouldn't just be something that makes me feel uncomfortable or I don't like, because in a free democratic space, which is what the original drafters of the Constitution had envisioned, the speech must have, consequences. It shouldn't cite some sort of violent response. And we're not necessarily saying that the response only has to be physical violence, because we do understand that just because, a riot didn't break out and someone didn't, beat you to a pulp, there's no violence that's been incited. So we do acknowledge that words in themselves can be violent to people, but that hate speech, it has a threshold. It has to rise to that level of violence. And it can't just be any speech that makes one feel uncomfortable or is not popular or is not politically correct, which is what the current act now, it's no longer the bill, what the current act advocates for.
So Liesl, and this is something else which is obviously concerning, is that there was a major hate speech case, the Qwelani case, which concerned not the criminalization of hate speech, but obviously the ability to be sanctioned for hate speech under the Equality Act. And one of the concerns about that case was, of course, that, and one of the arguments made by Qwelani was that hate speech in that particular piece of legislation was unconstitutional and unlawful. It had gone beyond the parameters that Norbert just pointed out. So maybe you could explain to us why or what the rationale was behind the Constitutional Court's judgment in that case.
Well, Michael, it's about the protection of freedom of expression. Norbert spoke about Section 16 of the Constitution, which protects expression. So you've got 16 subclause 1 with your specifically protected expressions, and then you've got 16 subclause 2 with your unprotected expressions. So unprotected expression is not necessarily unlawful, but it's not protected. It means the state has an option how to regulate that. And the Equality Act, which full name is the Promotion of Equality and Prevention of Unfair Discrimination Act, which was the act under which Qwelani was heard, is a civil regulation of hate speech. And the definition of hate speech in the act was too wide. It was wider than the parameters of the Constitution. For example, it had a disjunctive reading. It's very important when you have hate speech. It's speech that is harmful, and it incites harm. This is incitement. It advocates hatred and it incites harm. There's these two components that go together. And there's also Qwelani, the grounds of Qwelani was a ground that was not in the Constitution, but the Constitutional Court said that is also a valid ground for hate speech, sexual orientation. But the Constitutional Court looked at, they found importantly that speech that is merely hurtful isn't hate speech. Speech that is offensive is not necessarily hate speech. It's a very wide protection of freedom of expression. Of course, that also includes religious expression. And it's why, and the reason why is because it's such freedom of expression is such a cornerstone right of society. And as Norbert rightly said, we should not criminalize or sanction, even civil sanction, speech that I hate. It should be true hate speech, but that needs to be in line with the parameters of the Constitution. It needs to be in line with the international treaties that is binding on South Africa, and the guidances on those treaties that says the criminalization of hate speech is really a last resort measure reserved for the most heinous of circumstances, because freedom of speech is such a critical constitutional and democratic right and freedom.
And so given all that, I mean, given the fact that, as you say, international law says make sure that it's very, very narrow, specifically if you criminalize something, given the fact that the civil law, the Equality Act, was effectively amended by the Constitutional Court to bring it within very strict limitations. They, for example, were saying, if memory serves, that there had to be elements of vilification and detestation. In other words, it wasn't just something that was, just offensive to me or that really upset me, no matter how, sensitive I might be on a particular subject, because obviously, everybody can take offense at something, and what's offensive to me might not be offensive to you. But now here comes the Hate Speech Act. And what are the thresholds, if you like, that this sets for hate speech? Because this is now, and I think it's worth pointing out at this stage, not only a criminal offense, but it's a criminal offense that could put you in jail for up to 5 years for a first-time offense. It is quite, bizarre that it started off as 3 years for a first offense. Then when it was in the National Assembly, it was arbitrarily increased, despite everybody protesting, the 3 years to 8 years. And now it's been trimmed back to 5 years. So that's a long time to spend in jail for something. So you would expect, therefore, the threshold of hate speech to be very high. But tell us the examples, perhaps, or what are the definitions of the things that can now potentially have you arrested and tried?
Well, Michael, if we look at the definition of hate speech, first of all, the essential element of the crime of hate speech, because it's hate speech. Hate is not defined. And in the Constitutional Court's judgment in Qwelani, the court gives good definitions for hate speech, and many stakeholders said, please incorporate them into this bill, now act. And international guidances that interpret treaties that deal with hate speech and freedom of expression. For example, the Rabat Plan of Action says, please incorporate robust definitions. There isn't any definition of hate in this act. So that is a concern. And then there's the definition of harm. because that's a very big element. We said the first element is in speech that is harmful, incites harm, and must promote or propagate hatred. So harm is that first element. If you have speech that isn't harmful or does not incite harm, you don't have the crime of hate speech. But what is harm? The act goes wider than Qwelani, or wider than the Equality Act. The Equality Act has emotional harm, psychological harm, and physical harm. This act, the Hate Speech Act, has economic harm, and it also has social harm. Actually talks about social detriment and economic detriment. Social detriment is defined as basically as anything that undermines the social cohesion of South Africa. That is so wide. As an attorney, I don't know where that starts and where that ends. So you have something that's very subjective and open to interpretation, which means it's open to arbitrary application, which means this law might not be equally and fairly applied to everybody in all circumstances, because depending on the individual presiding officer who's dealing with this case, or the individual prosecutor or defense attorney, they might have a different definition because there isn't a guideline for what this means. And this is a new type of legislation. It's not like this is old territory and we have a lot to draw on. This is a new thing, so please define these terms. And then there's emotional harm, very subjective. Yes, the Equality Act speaks of emotional harm, but the Equality Act is a civil law, and we have to keep that distinction. There's one thing about having a civil sanction for emotional harm, and quite another thing for a criminal sanction for emotional harm, because the bar needs to be higher. And a big failure of this act is that the rebut plan of action, which is it sets the thresholds for criminal sanctions on hate speech, says they have this 6-part test. And again, we were one of the stakeholders that said, please include the 6-part test. It has not been included. And what it does, it ensures that that threshold is sufficiently high enough so that only real hate speech is criminalized as a last resort measure in strictly justifiable circumstances. So you have like real hatred there, you have real harm, and that freedom of expression is sufficiently protected, because otherwise you can have the most bizarre scenarios. And I don't want to make up scenarios, but as you say, one person can say something and then the person is emotionally hurt by it, but what is harm? And you've got all these vague definitions, and in the end it makes the criminal justice system very unsure. And a big issue around that also is that you don't want people to just kind of start self-censoring out of fear, because I don't even know what is expected of me. That makes this law contrary to the rule of law, because it's the person on the street. How would they know beforehand whether they're committing a crime or not? We're sitting here, Nob and I are both attorneys, and we're sitting like, what does this mean in practice? So how does a person who's not legally trained understand what this means in practice? So that's very, very concerning.
No, absolutely. I mean, the legal certainty, particularly when it comes to criminal law, is absolutely an essential component, obviously. But no, let me just throw this question to you, because obviously in South Africa, we have a history, a legacy, if you like, of racism. And one of the big rationales that the government was pushing forward to implement or to pass this act was the fact that it will be an effective sanction to racist speech. And I think I'd like to ask you maybe 2 questions. The first is, is this actually something that we needed in South African law for that purpose? And secondly, how effective is criminalizing hate speech typically, and specifically the type of speech that they're talking about, racist speech?
I'll take the question on racism. I think in South African law, one thing that's very clear is that this law was not necessary, because we already have laws that deal with racism in South Africa. Not too long ago, if you would remember the cases of Vicky Momberg and Penny Sparrow, these are individuals who were recorded, they were arrested, and they were sanctioned, and they were sent to prison for their racist utterances. And so from the first question is that we do have laws. We do need laws, obviously, to protect people from racist speech and speech that is triggering and very harmful and carries real life consequence, because we know that words carry meaning. So we are not taking lightly, when somebody is being racist to anyone, but the laws already exist and there's a system in place to deal with that. And we don't need a plethora of laws to deal with that. They're already there. And so if we had a government that was honest and saying that they do want to deal with racism, make use of the existing laws. There's nothing, to the best of my knowledge, no one has complained and said that, oh, this is insufficient, we can't prosecute all these people. And so in many ways, I think the hate speech bill was a political reaction to say this issue has come up and people are sick and tired of racism. And so we are going to appear to be doing something, such as promulgating a new piece of legislation that is meant to deal with racism, yet there's already sufficient legislation that exists to deal with racism. And this then leads on to the second question is criminalizing broadly this hate speech that is undefined, that is subjective, that offers no certainty in law, is this going to deal with racism in South Africa? And I think we can all safely say, absolutely not. What causes racism, there are deep layers of national healing that need to happen. There is a lot of issues around the economic justice and injustice in the country, and relations and crossing boundaries and things that cannot happen over one lifetime, and they simply cannot happen because you've legislated it. So we cannot police what people think. You can protect people from harmful speech, which already exists in criminal law, but you cannot try to police human relationships and things that are harming my feelings. And I don't like what this was said, because if somebody approached me and was deeply racist to me and said the type of words that are racist and criminalized in South Africa, I can simply walk to a police station and open a criminal case against them, and the police will arrest them. This was very present, this was very real, and I'm speaking from experience. This is something that is very possible outside of this new hate speech bill. All this hate speech bill does is it complicates an already complicated legal space, legal framework. And what it risks doing is that actually it may have the opposite effect, where because of the lack of certainty in law, no one will want to prosecute racism because they don't know where the case is going to go. And so this may have actually a detrimental effect, rather than ensuring that we have more prosecution of people that are racist, or beginning to deal with the issue of racism as a plague in our society. This may cause the opposite effect, where people are like, this is too much, we don't know what to do, this law is too ambiguous, I'm not going to touch it, I don't know which piece of legislation to use. And prosecutors who are already underpaid and overworked are not going to risk taking cases where the law is uncertain. And this is what this law does. It actually has the potential to set us back in dealing with racism than actually addressing it.
Well, that is a very interesting perspective, and I think you could be right. Of course, the big concern that we had for SA was the impact that this would have on potentially bona fide religious expression, because we live in a world, unfortunately, where some of the things that people believe sincerely, which their faith has taught them and has been passed down to them over centuries, has now suddenly seemed to be politically incorrect. And I think that perhaps one of the more concerning elements of this hate speech act is that there are now 18 categories of protected classes, so to speak, under this particular legislation, whereas the Constitution, I believe, only has 4. So it's broader and broader, the people who are protected from it. And of course, one of the things that may well mean, given the fact that some of those protected categories are things like gender and sexual orientation. And obviously, maybe it's important to just say, nobody is saying that anybody from a religious point of view should ever say anything that is, inciting hatred and harm against anybody. That's obviously reprehensible, and it should indeed be sanctioned. But I think the question of concern is that what happens if you say something that you may believe sincerely, that perhaps you're even quoting a scripture that somebody else finds to be, or you're interpreting a scripture that somebody else finds that particular interpretation to be harmful or to be causing me, as you say, substantial emotional harm, or maybe even seen to be undermining somehow the social fabric of South Africa as it now stands. Where is the protection, therefore, for people of faith who legitimately express without meaning to cause offense or hate, incite hatred or harm against anybody? What is the danger that people are in, would you say, under this current law? Maybe Lisa, you can pick that up.
Well, Michael, I think it's a real concern, especially when hate speech, because the definition is so wide and it's vague and it's subjective elements in that mix. And it becomes, speech that I hate, or even speech that offends me, instead of real hate speech within constitutional international law parameters, is bona fide religious expression protected? Now, the original version of this draft, when it was still a draft bill, it didn't have any, protection for religious expression. And then a clause was inserted, not only for religious expression, but also free of the 4 protected expressions under the Constitution. Interestingly, the exchange of information and ideas is not in there. But anyway, let's just focus on religious expression. So there's a religious exemption clause, but the devil usually is in the details. This clause is worded, but all these clauses, but this clause, like the rest, it's worded in such a circular fashion that it's actually self-defeating. And that means it provides little or no real protection, because it says, only harmful speech is basically excluded, but the caveat still refers to harm and hatred is not defined, and harm is this wide definition that contains these subjective and vague concepts such as emotional harm and social harm. And then you still have all the grounds, which are, I know it's not 18 clauses, but if you take all the subcategories under the clause, it goes to 18 different grounds with concepts, some of which are novel, some which are fluid, some which are contested in contemporary society. So then where is the protection? There isn't really a robust protection, and we don't want people being self-censored. And, we watch trends, we should watch what's going on overseas. And when we know about cases in Finland, of a member of parliament who used to be a government minister, who is facing criminal prosecution, round after round of criminal prosecution, because he quoted a Bible verse on a social media platform. And this is not the only case where a person who's quoted the scripture has landed in trouble. And of course, like I say, nobody's condoning hatred or really wanting to harm anyone. Of course not. But bona fide religious expression and living out your faith freely and without fear, without hindrance or fear of sanction in the public sphere is something that should be protected. And what is concerning about this act is that whereas the Equality Act it does not apply to private communications. Private communications is excluded. The Constitutional Court confirmed that. This Hate Speech Act does not even exclude private communications, but it should not only be private, it should be public as well. There's a value to constitutional democracy to have this robust exchange of ideas within certain parameters, that it's not hateful and you're not inciting actual harm against people, of course. But that is a concern for bona fide religious expression, especially in the world where certain things, traditional ideas about marriage and gender, become very contested, and people who hold to very traditional views on faith, their views might be seen by some as hate speech, not because it is actual hate speech, not because there's any hatred in their heart towards anyone or they want to take away anybody's rights or anything like that. No, but because some people hate that speech. And there's a distinction. You can have an opinion based on a religious text and say, this is my sincerely held belief on this religious text, while at the same time saying, even though you view something differently, I completely recognize and respect that you have inherent dignity and equality as another human being. I just have a different opinion.
Yeah, very, very concerning. And I think the other thing, Nobu, this is something I'd like to get your take on as well. We obviously were grateful that there was opportunities for the public to have their say. Our Constitution requires that when a law is going to be promulgated or is being considered, that there is a level of public participation and public consultation. And I calculated that just the public participation number that we know of is just under 200,000. That's just through one single platform over 4 different elements of that public input. What do you make of the way that government has actually seemingly not adhered to that? And why in law is that problematic?
Thanks, Michael. I think the big thing is that perhaps the euphoria of a post-democratic South Africa has dwindled down in our government, and the ideas of building society collaboratively with people are not something that is sacredly held, anymore, because the idea of public participation is part of the Constitution to say that our government is a government for the people, by the people. And this requires that you listen to the people and you take the opinions of the people and you listen to them. And we have, our law is very clear. It's very clear in the Constitution, and we have had some cases, none of which actually pop up in my mind immediately, but we have had constitutional thinking around public participation and why it is crucial for a democratic country to hold fast to what other people are saying. And in this particular case, you had these large numbers of people giving the government their opinion, and you had that opinion being ignored. And this idea that public participation, is somehow a tick box in part of the administrative law process and not actually an essential element of lawmaking is something that needs to actually be challenged and changed, because they didn't consider the public input. And this is a trend that we've seen in a few other cases. And in some instances, you do have places where the government really considers public input and they change the laws accordingly. But sadly, for such an important law, this is not one of them. They haven't done that. And as Liesl said, even in the exclusion clause, religious speech is protected if it's not hate speech. Well, that means nothing. And the public specifically brought that forward and said, this doesn't make sense. There's international precedents, and they didn't consider that. And what it actually means in law is that this law can be challenged. Its constitutionality can be put to the master, and the Constitutional Court must then consider what is public participation? What is meaningful public participation? Is it just opening, gazetting, and saying, give us your opinions, and then you shelve those opinions, and you say, well, we got everybody's opinions? Or is it considering them, changing the law accordingly, and making sure that the laws that we promulgate in South Africa speak to us as South Africans, as a majority, as the people who give our opinions to the government, and the government is meant to take those opinions and make them into laws that we can adhere to, because we don't live in an old era of whether it was the apartheid government or era of kings where laws are put to us and we must abide by them. This is what a constitutional democracy means, is that we participate in the lawmaking process so that we take ownership of these laws as the public, and that they're able to be implemented. And it has the effect of reducing lawlessness as well, if people feel that they're a part of the process. And in this case, where the public's opinions are ignored, then you don't have public buy-in, and it ultimately affects the effectiveness of that law. And so hopefully, moving forward, this law will be challenged, and the Constitutional Court has the option and the opportunity to clarify what does meaningful public participation mean, and what are the government's obligations to consider the input of the public in the lawmaking process.
Yeah, so essentially we've got two, I would say, big issues. And I do believe that we're obviously just before SA, because we were just one among many who were from different perspectives expressing deep concern about something which is, as I think you've both eloquently said, it is critical to a robust democracy to have as much free speech as you possibly can, and that's obviously been significantly curtailed. So obviously legal challenges is afoot, almost inevitable, on probably two different elements. The first would, of course, be the constitutionality of it. Is this particular piece of legislation constitutional? Does it pass constitutional muster, as they say? And secondly, has the process been properly followed according to the laws that we have, which govern the way that our lawmaking process works? So it's going to be, I think, a very significant development. And in a sense, it's going to bring to a head, perhaps, some very critical issues that have perhaps been left somewhat undecided, shall we say. So look out for that. But maybe, Louis, you could tell us, obviously we're going to now consider our options, freedom of religion South Africa 4SA. Most certainly we will in some way be involved in challenging this law. So essentially there are two elements that are potentially needing to be challenged going forward. The first is, of course, the constitutionality of this law. Has it gone beyond what the Constitution allows? Has it not adhered to the international treaty obligations of the South African government when it comes to the lawmaking process? That would be perhaps the first element, is the constitutionality aspect. And obviously the second aspect is going to be, did they follow the proper process that the law requires to make valid laws? Particularly, this is a very serious issue, because speech is a fundamental element of any democracy, and a law which criminalizes in a vague way speech which should otherwise be legitimately allowed, and the Constitution would actually certainly permit and protect. Potentially this law now leaves unprotected. In fact, on the contrary, it may even put you in jail. So maybe you could just give us an outline as to what are the next steps. Where is the application of this law as it currently stands, and what are the steps and the likely timelines going to be, so that potentially it can be challenged and found to be unconstitutional and even unlawful?
So I'm going to defer part of this question to Liesl, because in an earlier conversation that we had, she had some wonderful insights onto some of the specifics of the application of certain provisions of the law. But as it currently stands, that law is in effect effective. The president has signed it into law, and we may begin to see prosecutions on the basis of this law any day now, because it is now actually the law. And it is the next steps are for 4SA, our partners, to then put together the legal minds. You would need to get the big legal minds and the free speech advocates to come together and begin to consider how to challenge this law. You don't necessarily need to wait for an ideal case or something to come before the courts for us to be able to challenge this law. The Constitution allows for us to challenge this law in the immediate, but it does take time to put together a legal case. There are many parties that are involved. I think any freedom-loving South African should be concerned with this particular case, and there are organizations that do specialize in free speech advocacy, and they will also be looking at taking this case forward to the Constitutional Court and giving them an opportunity to rule on the issues that you have highlighted, Michael. But I'd really love to hear from Liesl some of the points that she raised earlier, because I think it's very pertinent for the public to know and understand what this effectiveness of this law means.
Yes, well, like as you said, Nobu, this law has been assented to, it's been gazetted, so it's been promulgated, so it is in force. But the Act also provides for instructions to be issued for the police concerning how hate speech is to be investigated, for directives to be issued to the National Prosecuting Authority for the prosecution of hate speech. So it's a question: will prosecutions, investigations wait until those have been issued or not, and how will the process work around that? But I mean, potentially it could be issued very quickly, or because hate speech was committed, now that the act has been assented to, even though when the directions come into force, then it gives them something, you know, they'll know we will investigate this matter or prosecute this matter according to the directives, even though it took place now. And then, yeah, another question is, how will these issues and directives, how will they come into being? Will they be done through regulations? Because this act has a provision where the regulations can come into force after 60 days, which does not necessarily require parliamentary oversight. Ideally it does, but it does not require it. So then that raises concerns about parliamentary oversight. But as you said, Nobu, this is any person who values freedom of expression. For them, this is an important case. And of course, freedom of expression includes religious expression. So, you know, we have our specific mandate, but broader civil society and civil liberties advocates are very concerned about this act as well, and really should consider seriously the road to challenging this. Our democracy, our freedom of expression is way too important to allow something on the law books that is arguably very unconstitutional on both substantive and procedural grounds. But it might be some road, because when a civil society stakeholders such as ourselves or somebody else would challenge a matter like this, you start at the High Court and you work your way up to the Constitutional Court. But it is worth doing, because this is such an important matter.
Yes, thank you. And I trust that everybody has found this interesting, this discussion. And I just want to take the opportunity to say thank you so much, Nobu, for joining us from where you are in the USA, Liesl for staying up late. And we certainly will, for SA, be obviously involving ourselves in this deeply, because there is perhaps no more serious threat currently that we face to our religious freedom than the potential of literally being jailed for something which might be a legitimate expression of your faith. So you can rest assured that 4SA will be and continue to be at the forefront of the fight for faith and freedom. So in the meantime, thank you so much, everybody, for your support. Please continue to support 4SA. We are entirely dependent upon the support of those who we fight for to support us and to finance our efforts. So thank you so much, and we wish you a very good evening, and God bless.